Okay, our final presentation of the day, initial and ongoing compliance and debt issues. Mr. Jason Akers has over 20 years of experience as a public finance attorney. As a managing partner with Foley & Judell, Mr. Akers works with public entities throughout Louisiana on bond issues and other types of financial arrangements. In addition to serving as bond counsel on finance issues, Mr. Akers also represents his clients in various economic and community development activities. Mr. Akers is a member of the Board of Directors and Executive Committee of the National Association of Bond Lawyers and an elected fellow of the American College of Bond Counsel. Please welcome Mr. Jason Akers.
Thank you, Lizzie. That was a very, very humbling biography I wrote of myself. I appreciate that. As she said, I'm Jason Akers. Happy Wednesday, happy last hour of the day, happy Fed Day. To those of you who haven't been paying attention, the Fed raised rates 75 basis points, throwing our municipal market into another state of flux that we don't know where it's going or how it's going to work. But with that backdrop, we're going to talk about bond issues. And we're going to talk, first of all, about various types of debt that you or your public entities may issue. I'm going to focus on local government subdivisions and local political subdivisions, so parishes, school boards, cities, districts, etc. For those of you that work more on the state level, you'll catch some common themes, but they won't necessarily focus on various state agencies or the state as a whole. But I think that you'll see some benefit to what we talk about throughout. So we'll first start off talking about various common types of debt. Next, we're going to talk about what is not debt. And that is important because our next conversation is going to be the State Bond Commission approval requirements and processes. Then we'll work kind of chronologically from there through the sale of the bonds and your ongoing compliance obligations and covenants that you have associated with any sort of bond issue during the time that it is outstanding. And then finally, we'll talk about continuing disclosure requirements, both for private debt and for publicly offered debt through SEC Rule 15C 212. So with that in mind, let's move straight into common types of debt, and let's start with general obligation bonds. Now, there is a difference in the legal designation of general obligation bonds in Louisiana versus what is referred to often as general obligation debt in notes to financial statements. When I, as a bond lawyer, refer to general obligation bonds, I'm referring to what the Louisiana Constitution calls a general obligation bond. That's a bond that is benefits from a pledge of the full faith and credit of the local government that's issuing that bond. That is payable, secure by and payable out of an unlimited ad valorem tax that is only used for the payment of debt service on those bonds. And it can only be issued pursuant to an election, meaning that there has to be an election called authorizing the issuance of the bonds, and then the bonds are issued pursuant to the terms of that election proposition. We'll talk about refunding bonds in a little bit. If you have authorized general obligation bonds, you can refund those without an election so long as they're savings. We'll talk about that in a little bit, though. The election requirement is kind of the key here, because if you're going to tax your citizens, then you need their permission to tax them. And thus the election is authorizing the issuance of bonds with the notation that they will be paid for out of an unlimited ad valorem tax. When you are looking at this from a compliance perspective, your initial compliance concerns are really are the terms of the bonds within the election parameters. That would be the purpose. The election parameters would include the purpose of the bonds, or the proceeds of the bonds. Secondly, would include the maximum principal amount to be issued. Third, it would include the term of the bonds. And then fourth, the maximum interest rate. In Louisiana, we also have to state what we anticipate the millage rate to be levied in the first year of issue, and that would be cumulative for all outstanding bonds that have been issued. Those bonds get issued. There's a tax that's levied to pay the debt service That tax is separate and apart from all other taxes that are levied. Those proceeds are received, they're placed into a sinking fund. That sinking fund can only be used for the payment of debt service. The funds in the sinking fund cannot be used constitutionally for any other purpose other than the payment of debt service. And I understand there was a little bit of a discussion about that earlier, so I'm just going to move straight on from sinking funds right now. And then finally, the last compliance concern is, does that bond issue actually exceed the authorized debt limitation of the issuer? That's set by statute, and there are different debt limitations set for each issuer. The debt limitation for general obligation bonds, however, only takes into account general obligation bonds. You don't aggregate sales tax bonds or utilities revenue bonds or anything else with your general obligation bonds to determine your debt limit. So this is a question we get asked often. What is the debt limit? What's my debt limitation? And that's just, a general question. Somebody may call and say, what's my debt limitation? And my response is typically, well, what kind of bonds are you talking about? Because each different type of bond we're going to talk about today actually carries with it its own debt limitations. Most of those are based on debt service, aggregate debt service or debt service within a particular year. General obligation bonds are the ones that are based on the amount of debt actually outstanding, the amount of general obligation bonds outstanding, and usually it's by comparison to your total assessed value within your particular entity. Baseline is that's a 35% limitation, but again, that changes for each one of each different issuer or type of entity. The last thing just to mention there is when we talk about the term of general obligation bonds, a lot of times propositions authorize the issuance of those bonds in multiple series. So you may have a client that has an election next week to issue, let me just throw a number out, $20 million of general obligation bonds in one or more series. The maximum term of those bonds may be 20 years. Well, that's 20 years for each issue. It's not 20 years from the date of the election. So if you wait 2 years to issue the first series, then you've got 20 years for that series. If you wait 2 more years to issue the next series, it's 20 years from the date of delivery of that series. So each series issued pursuant to the proposition has to meet the requirements of that proposition. That gets confusing from time to time because we do have questions about whether a tax can continue to be levied beyond the term that's allowed by a proposition. Well, that's not exactly what the proposition says. The proposition says that the bonds won't go longer than 20 years from the time they're issued. The Constitution says that that tax has to be levied while the bonds are outstanding. So moving on to next type, tax secured bonds. Well, I just said that general obligation bonds are payable out of an unlimited ad valorem tax. So what's the difference here? Well, the difference is these are not general obligation bonds. First of all, bonds secured by either an existing sales tax or existing ad valorem tax are not general obligation bonds, primarily because that tax is limited. It's not unlimited. And I'm not going to tell you the difference. I think you all know the difference between limited and unlimited, but for an existing tax, it is levied at a particular rate. And it cannot be extended or increased beyond a particular rate without typically voter approval. There's some exceptions. Just take it there's going to be an exception, at least one exception to everything I say up here today. But without voter exception typically, or voter approval typically, an existing tax cannot be increased over the amount that's currently being levied. Secondly, there is no election requirement for the issuance of bonds secured by an existing sales tax or existing ad valorem tax. There may be an election requirement to put the tax into place, but there's not an election requirement to issue the bonds. There used to be. Many years ago, there was an election requirement to issue sales tax bonds. That is no longer the case. You can issue, as long as you have the tax outstanding, you can issue bonds that go out as long as that tax goes out. If the tax is in perpetuity, or maximum 30 years, but if the tax is in perpetuity, you can go 30 years. If the tax only has 8 years left before it expires, pursuant to the terms of the proposition, you can only do bonds for 8 years secured by that tax. You also have a limitation on the amount of bonds that you can issue secured by a tax. That limitation is basically set as on the year of issue, and it's a percentage of the revenues produced by the tax in the year that you issue. And it's stated this way, legally. The debt service on the bonds that are being issued aggregated with all other bonds outstanding secured by that same tax cannot exceed 75% of the revenues of the tax produced in that year. Again, there are exceptions, but typically it's a 75% test. Sometimes you may see that written as a 1.33 times test or 133 times test. Why is that? Well, 75% is 3/4. Sometimes we flip it around. The inverse of 3/4 is 4/3. 4/3 when turned to a percentage is 133%. And sometimes instead of saying that the debt service cannot exceed 75% of the revenue, sometimes it says that the pledged revenue must be at least 1.33 times or 133% the maximum aggregate debt service. So I want you to understand that that's sometimes the difference. It's the same test, sometimes it's just written differently. And again, it's based on the amount of revenue produced by the tax in the year of issue, but it looks at the maximum annual debt service. In other words, you don't get to typically take advantage of any anticipated growth in tax revenue that you may see in future years. You have to look at the revenue that's produced in the year that we issue. Let me stop also. Are these revenue bonds? Well, you know what? Kinda. I mean, there is revenue produced by the tax. It is kind of a revenue bond. There are certain statutes that refer to sales tax bonds as revenue bonds. There are certain statutes that refer to ad valorem tax secured bonds as revenue bonds. There are also other statutes that refer to them as sales tax bonds or limited tax bonds. Just as you're looking at it, sometimes you may see those referred to as revenue bonds. That's just a nomenclature issue that doesn't really make a difference in the grandest scheme of things. What are your initial compliance concerns in going through these? First, does the purpose of the bonds match the pledged revenue? If you have a sales tax that is authorized for road and street improvements, you can't use that sales tax to secure bonds that are for water system improvements, for example. You have to respect the purpose of the tax. If you have a tax that is levied for general purposes, you can do just about anything that you're legally authorized to do and secure bonds for that. If you choose to. But that is typically contained within the proposition or the authorizing legislation that authorizes you to levy that tax. Secondly, is the amortization permitted under state law? We just mentioned that, that 75% test or 1.33 times test. And then finally, has the issuer established the proper accounts? I'm going to put a pin in that because we're going to talk about this after the fact. But within the context of any bond issue, often there are a number of funds or accounts that are required to be established and funded in a particular way. And that is an initial setup requirement. So we'll talk about what those accounts and funds are a little bit later on. Just want to note that if you go back looking at these slides later on, you say, what proper accounts, why is that here and back there? Well, because it's an initial setup requirement, and then it also is something that you'll have to maintain and respect as you go forward. Utilities revenue bonds. We're rolling right through everything, so if you have questions, just let me know. But utilities revenue bonds. Let's start off with the simple question: what is a utility? And that sounds easy enough, but that actually is a much more difficult question to answer. Luckily for us in Louisiana, we have very simple definitions contained right in Title 33 of the Louisiana Revised Statutes. And a utility is any revenue-producing public property of a governmental entity. So a water system, a sewer system, an electrical system, those are all obviously utilities. Those are traditional utilities. But a hospital, a publicly owned hospital, is also a utility. An office building that a public entity owns that leases out to others is technically a utility. That doesn't bring you into a whole host of new compliance requirements that you didn't already have. What it means is that from a definitional standpoint, there's a few things that kick in for us. First of all, it's something that you can use the revenue from to secure debt service and the repayment of bonds. Secondly, you can't just up and sell most revenue-producing public properties without having an election to authorize the sale. The reason for that is because typically they're funded with public public funds, and you don't want to just dispose of something that was funded with public funds without having the approval of the public itself to be able to do so. So once we've established that we've got a utility and we're securing bonds paid out of the revenues produced by that utility, the next question is whether they benefit from a net revenue pledge or a gross revenue pledge. A net revenue pledge is a little bit more beneficial to the public entity. A gross revenue pledge is more beneficial to the bondholders. Gross revenue pledge says that any revenue produced is going to first go to pay debt service, whereas a net revenue pledge says that any revenue produced is first going to go pay the costs of operating and maintaining this utility, and after that it's going to go to pay debt service. You may be thinking, why would any bondholder agree to take after the payment of operating expenses? Wouldn't a bondholder be in a much better position if they took the first revenues? Well, that sounds right, except for the fact that most utility bonds are outstanding 10, 20, 30 years. And if you're buying a bond issue and you may get that 30-year maturity, you want to make sure that you actually have a utility that's still going to be in place and operating and producing revenue for the full 30 years that you're holding that bond. That's why you do a net revenue pledge. It sounds like it's less of it sounds like it's more of a revenue risk for the bondholders and less beneficial for the bondholders, but it actually is more beneficial because it ensures that the utility is going to remain open and operating that entire time. A lot of times within utility revenue bonds, you may take a look at something and see that there's a pledge of a utility system as a whole, and it's referred to as a combined system. Even though revenues of the bonds may have gone to pay just for a water system, the security may be the water, sewer, and gas system, just to throw a few out there. That is, even though they may be accounted for in separate funds, a lot of times we will see those combined for bond purposes to enhance the value of the security of the pledged security and the revenues that are pledged to the payment of debt service. That is a good way for you to take maybe a utility that produces $1 million in net revenue a year and get the benefit of 3 utilities, each of which produce $1 million in net revenue a year. That allows you to borrow more, allows you to treat the system as a whole. A lot of times your water and your sewer systems, while mostly divided, will share some particular components, and you can pay for both of those with a single bond issue. A lot of times other funds are allowed to be used to support the system, and in this case the documentation really matters. If the documentation allows for those other funds, be they tax revenues, general fund revenues, or et cetera, to be used for the benefit of the system, they can typically be used for coverage calculation purposes. We'll talk about coverage calculations at the end as well. The key here is whether those are pledged, or those other funds are pledged, or just allowed for use. If they are pledged, then that means the bondholders have a right to force you to use those revenues for the payment of debt service. If they are just allowed for use and just recognized within the documentation, then that becomes a decision that's made, a budgeting decision for the governmental entity. Just to give an example, if you have a sales tax or an ad valorem tax that can be used for multiple purposes, and you decide that one of those purposes is going to be to support your water system so you can keep rates lower, well, if that's the approach that you're going to take, your bondholders may say, we get that, but we also want you to commit to using a certain amount each year to support that water system. Sometimes we have mortgages associated with utilities revenue bonds. This is more common in USDA type financings. It's more common with hospital revenue financings or lease revenue financings. It's not as common with traditional bond issues that are secured by water systems. Our compliance concern with the mortgage is ensuring that we follow all the very particular rules of the statutory structure that allows for the grant of a mortgage. If we don't follow those rules, then suddenly we have an ineffective mortgage. I'm putting aside the questions of whether a bondholder can either execute on a mortgage, because there are certain Louisiana constitutional provisions that surely indicate that that's not allowed. That's why I think we see them more rare these days than they certainly used to be in the past. Again, just initial compliance concerns: is this amortization authorized under state law, and proper accounts as well, much like with the tax secured bonds. So refunding bonds. I tell my clients that refunding of debt is much like refunding your home mortgage. You're taking old debt at a higher interest rate out. You're putting new debt at a lower interest rate in its place. I didn't click, sorry. New debt at a lower interest rate in its place, and you're saving money as a result. This is what's commonly referred to as an economic refunding. A lot of times you might have a non-economic refunding as well. In its most basic terms, a non-economic refunding is a refunding that doesn't produce present value savings in each year. You may ask, why would you go through that? Well, there may be other reasons to go through a non-economic refunding. You may need covenant relief, you may need debt service relief, you may have a default risk, and therefore you need to spread your debt service out over a longer period. We actually saw not so many in Louisiana, but we saw a number of these types of non-economic refundings during COVID, when there were a number of public entities throughout the nation who were really worried about what their revenues were going to continue to look like in the coming period, and they would refund and extend some maturities to provide debt service relief in the early years, but extend them for longer years. It's fine, it's acceptable, it's just something that is not commonly used, because we like to pay off the bonds in the time in which is initially anticipated. Sometimes, and probably this is obvious, I'm not a CPA and I'm not a GASB expert, but I'd also say, with respect to non-economic refundings, don't get confused by the first year, because your savings on an economic refunding are typically realized over the remaining term of the bonds. That may be 10 years, it may be 15 years or 20 years, but under GASB, as I appreciate it, those issuance costs are now recognized within the year of issuance. So if you look at your issuance costs, if you've got 20 years of savings, your issuance costs may exceed your annual savings in the first year, and it may look like you've got a non-economic refunding as a result. But when you look at it on the whole, there are savings in every year. Our issuance costs are amortized. They are actually amortized, even though GASB doesn't recognize them as being amortized anymore. There's a difference between redemption and defeasance. Redemption is the day on which the bonds are paid off early. That is called the redemption. There is a defeasance allowed that's recognized in Chapter 14 of Title 39 that actually states that if funds or government securities, we call them defeasance securities, they're high value government securities, are deposited in escrow for the repayment of debt on the first call date, then that is referred to as a defeasance. And if bonds are defeased, they are no longer considered legally outstanding. You accomplish that through an escrow agreement and a verification that those funds that are deposited into that account are going to be sufficient to pay all interest that's due on those bonds to the date of redemption, and the amount that is actually and the principal amount that would be due on that date. So a lot of times what you might see is a refunding that doesn't actually result in a redemption until a year or two down the road. That's where this State Bond Commission minimum savings schedule comes in. If we're going to State Bond Commission for approval of a refunding, then we want to be able to show that we can meet this minimum threshold of savings, and this time calculation that's on the left side of the equals is actually the time between the delivery of the refunding bonds, the new debt, and the redemption of the refunded bonds, the old debt. So if you have 48 months between the time you deliver the new bonds and you're going to redeem the old bonds, if it's going to take 48 months or longer, you've got to show a 5% net present value savings. That's a very high threshold to hit, but if you can hit it, then the State Bond Commission recognizes that there's a benefit, a tangible economic benefit to you going ahead with the refunding, notwithstanding that long period in between the two. There's a lot of other kinds of debt out there. I mean, it would take, we've probably spent too much on what we have already, but it would take a long time for us to go through them. Excess revenue bonds, also referred to as certificates of indebtedness. This is a kind of a net pledge to pay debt from funds that are remaining after paying all legal, contractual, and other required expenses of an entity during a year. It's essentially a general fund pledge, but it does carry with it a pledge to budget enough funds each year to pay that debt service. General fund loan is just basically, hey, loan me $100,000 and I promise I'll pay you back. It's out of whatever funds I have available. Cash flow loans, referred to as revenue anticipation notes or certificates of indebtedness, is a borrowing within a year for operating expenses within that year, and those are paid out of revenues incurred in that year. No offense to anyone in here. This is not a criticism. This is merely a fact. Those are typical of those entities who have a fiscal year that begins July 1, but they don't get tax revenues until January 15. A lot of times there's a need to bridge a gap in that 7-month period between when the fiscal year starts and when the tax revenues are received. Bond anticipation notes and grant anticipation notes are exactly what they say. Bond anticipation notes, interim financing when the bonds aren't going to be issued for a while, essentially provides construction financing. Grant anticipation notes, should have kept Charlie around. The grant anticipation notes are whenever there's a grant, typically grants are reimbursement, and so when you have a grant and you need to front the funds in order to be able to get the grant proceeds, grant anticipation note allows you to do that. Special revenue notes, leases, paid out of special assessments, anything else like that. Development financings, community development districts, economic development districts, those are very common these days, certainly more so than they were 20 years ago. My advice to any client that I'm working with is that whenever you issue debt, you have to understand that you're obligating the payment of that debt service over any other budgetary priorities that you may have during the entire term of the debt. So if you are issuing bonds secured by an ad valorem tax, not general obligation bonds, but secured by an ad valorem tax, then you are prioritizing that debt service payment each year over anything else you're going to use that ad valorem tax for. If you're issuing utility revenue bonds, then you're prioritizing that each year your utility is going to produce enough revenue that you're going to be able to pay debt service at the end of that year. And I would say that's just take that with you. The consequences of not paying debt service are severe, and they involve you giving up an awful lot of control over your particular entity. I know that this audience probably understands that a lot better than other audiences that I speak with from time to time, but fiscal review or fiscal administrators are not anything you want to get involved with, because it's going to take a lot of time and it'll be forever before you get out of it. So, all right, we've talked about debt. Real important discussion to have now is what is not debt. For starters, under 39:1410.60, what is not debt is a lease of a movable that meets certain criteria. A movable is defined in Louisiana law by reference to what it is not. A movable is not an immovable, immovable. An immovable is essentially anything that any building or structure or permanent improvement or anything affixed to it that can't be removed without jeopardizing the value of that immovable. A movable is anything that's not an immovable. Okay, so equipment, copiers, that's the easiest example. We'll talk about copiers. So copiers are immovables. I'm sorry, copiers are movables. See, I got confused. Copiers are movables. Leases of copiers are exempt from State Bond Commission approval requirements. They are not considered debt under Louisiana law. Louisiana law, not GASB. I'm not even going to get back into that one now. So as long as that lease contains a non-appropriation clause, meaning that it's essentially a year-to-year obligation, you can non-appropriate at any time, that there's no anti-substitution clause contained within the lease. An anti-substitution clause says that if you've got a 5-year lease for those copiers and in year 2 you decide you don't like those copiers anymore, you can't non-appropriate and go get different copiers. That's an anti-substitution clause. You cannot have an anti-substitution clause. We've got a lot of double negatives happening right now, but you cannot have an anti-substitution clause within your lease if you want it to meet the exemption in 39.14.10.60. And then finally, there can be no penalty provisions. What is a penalty provision? That part's really unclear. Essentially, I think of it as anything that's going to require you to pay money that you weren't otherwise anticipating to pay in the event of a non-appropriation or other desire to cancel the lease. That would be a penalty clause. You are not allowed to have a penalty clause within these leases for them to be exempt from the State Bond Commission approval requirement and the definition of debt in Louisiana. Next, though, is non-appropriation debt. Well, this is pursuant to a line of AG opinions that were really begun under a statute that was preempted by 39.14.10.60 with the lease of immovables, would have been carried forward by the Attorney General, and I'm not one to tell the Attorney General to do his job differently. So if there is a non-appropriation obligation, also referred to as a moral obligation, that can be non-appropriated at any time, and there's no restrictions on that ability to non-appropriate, and there's no UCC filed with the equipment or anything like that, the Attorney General says in a long line of opinions, far beyond our current Attorney General, reaching back a number of years, that is not debt in Louisiana and does not require State Bond Commission approval. There is an argument that that statute, pursuant to which those AG opinions were initially rendered, is no longer valid, and therefore those opinions shouldn't be considered. That's just that's an argument that has not been determined one way or another in court. But that leads us to what we're seeing more and more now are P3s, public-private partnerships, and CEAs, cooperative endeavor agreements. And these are a facts and circumstances analysis for each one. The Attorney General's opinions say that debt is more than an obligation to pay a sum of money. Debt is incurred when there is a financing. All right, that sounds really easy, right? But the problem is there's a lot of gray areas in what is a financing. What exactly does that mean? And I want to just have you think through something with me. Just indulge me in this exercise real quick. So I'm going to say a parish council gives a parochial water district $1 million to lay a water line from point A to point B. So the obligation is contingent upon repayment if money is appropriated. That doesn't necessarily sound like debt. But what if it's obligation to repay at 4% interest if money is appropriated? Okay, that's starting to sound a little bit more like debt. What if it's an obligation to repay? Now remember, this is from a parochial water district to the parish council. It's creating its parent entity. What if it's an obligation to repay at 4% interest from a dedicated source of revenue as long as it's appropriated? These are indicia of debt. And unfortunately, there's a lot of gray area here. There was an August 30 of this year letter from the Legislative Auditor and the State Treasurer that warned public entities about the unauthorized incurrence of debt without State Bond Commission approval. And they actually listed several indicia of debt within this letter. And it's been helpful But it continues to be tested in a lot of ways. Those indicia of debt are included in the PowerPoint and on the screen right now. But it's financing, construction, or pre-construction interest. Ownership is a big deal. Whether there's an interest rate, expressed or implied. It could be an implied interest rate. It could be an increase in payments upon use. It could be an increase in payment upon lack of use. Anything like that could be considered to be an interest rate. As I mentioned ownership. If there's a grant of a security interest, well, if you as a public entity, if you don't own it, you can't grant a security interest in it. But if you do own it and you're asked to grant a security interest, is that indicia of debt? Because typically you can't grant a security interest without there being actual debt. So these I would encourage, and I'm sure Diane would be glad to provide anyone the August 30 letter from Mike and from the state treasurer. But it's it's very helpful just to consider what is out there and what you should be looking at when your public works guy comes and says, "Hey, I've got a really good way for us to finance this new water treatment plant that we need to do." And the reason all of this is important is because of the State Bond Commission approval requirement in Louisiana. Let me first and foremost say, don't get caught up in the word bond in the name State Bond Commission. Bond is just a fancy word for loan. Any obligation for the repayment of money is potentially subject to State Bond Commission approval. And I'll direct you to a few statutes and constitutional provisions in the PowerPoint. Article 7, Section 8B says that no bond or other obligation, again, it's not as specific as just bonds. It's far more encompassing than that. But none shall be issued or sold by any political subdivision unless prior written approval of the State Bond Commission is obtained. 39-1410.60. This is a prior draft of or prior provision of the statute I mentioned earlier about leases of movables, that no political subdivision shall issue any debt without consent and approval of the State Bond Commission. Under 39-1410.63A, I want you to note that any contract, debt, obligation, bond, or other evidence of indebtedness. See, now we've gotten even more expansive than bond. We're actually any contract at this point with whatsoever incurred without the consent and approval of the State Bond Commission shall be null and void. It's not voidable, which means that there's some sort of action that has to be taken to avoid repayment. It is void from the very moment it was supposedly entered into. It was never a valid obligation, and therefore using any funds of a public entity to pay an invalid agreement would be a violation. What kind of violation? Well, that same statute goes on to tell us that for any public officer that engages in any sort of obligation, or even attempts to engage in any sort of obligation that should get State Bond Commission approval, but does not, that officer shall be fined not less than $100 and not more than $500, and imprisoned for not more than 6 months. So I don't know about y'all, but I'm not ready to go to jail for anything that I'm doing in my public life, and I don't think any of you, I don't think you would be here if you were ready to go to jail for that. So that's why this gets very important. So let's talk a little bit about the State Bond Commission approval process, because once we've decided that there is an obligation that requires State Bond Commission approval, then how do you actually go about that? Well, the State Bond Commission actually meets on the third Thursday of each month, absent moving that for something really important like maybe Washington Mardi Gras. But third Thursday of each month is their regular meeting date, and all the application requirements kind of fall back from that. So you have to start the process with adoption of a preliminary resolution by the governing authority that asks the State Bond Commission to approve, and it sets the maximum principal amount, maximum interest rate, and maximum term of that obligation, and states the security for the bonds or obligations that are proposed. That is then submitted to the State Bond Commission prior to an application deadline, which is usually 30 days prior to the meeting itself. along with certain required forms and a list of all the costs of issuance included in an Excel file that we call the financial disclosure form. All the costs of issuance gets included, gets provided to the State Bond Commission. There's then a review period where they assign an analyst. The analyst goes through all that is submitted, sends an email and says, I need this, I don't understand this, so can you please explain it a little bit more? And it would also be helpful if maybe you provided this as well. And that typically goes to the entity to the person that files the application. A lot of times it's us as bond counsel, not always, but a lot of times it's us as bond counsel. And then we work with our clients to ensure that we provide all of that information and that we're providing it to them accurately and quickly, because they're working up to a 10 working day deadline. So if the meeting's on the third Thursday of each month, the 10 working day deadline is the first Thursday of each month, 2 weeks before. And that's when it's kind of pencils down. They want to have all information in. As they get all information in, they are then working the next few days to complete their analysis sheet. They're working with us as counsel to ensure that they're accurately explaining everything on that analysis sheet. And that leads to an agenda review, which is not an official committee, but the agenda review panel is typically representatives of the legislative auditor, representatives of both the House and the Senate, representatives of the Division of Administration, and they're gathering the information to then report back to their bosses, for lack of a better term, but they're folks, because the State Bond Commission membership is our 5 highest ranking statewide elected officials, plus the commissioner of the Division of Administration, and then 4 senators and 4 representatives. That adds to 14. I don't know why we decided 14 was the right number, so that we'll have ties at the State Bond Commission, but ties are rare. They really are. But the information shared in the legal and financial analysis that's shared with the agenda review panel is then shared with the members, and over that period between Monday to Thursday at the meeting is essentially, for us, it's triage. We're taking questions as they come in. If there's something if we have a project in the Speaker of the House's district, he may want to say, well, what exactly is this that you're doing? Please explain it to me a little bit more. And we'll certainly be responsive to all of those. So then we get to the meeting itself. And the meeting is those 14 members or their designees sitting at the Bond Commission. Then there's the executive director, Leila False is her name, and Leila reads out the application, explains the purpose. There's a chance for questions. We answer questions to the extent they're asked. If they're not asked, then typically there's a motion for approval, a second, and there's a voice vote in favor. That's the good way for it to go. The other way for it to go with other applications is that there's a long process of explaining everything that goes into it and answering any questions. As a regulatory entity, the State Bond Commission can ask any question essentially that it would like. It doesn't have to base its decisions on the facts before it. And they actually have an Attorney General opinion on that as well. Trust me, I represent the entity that runs the Superdome, and we got a question one time at the meeting about why the hot dogs are so expensive at the Superdome. Still don't know the answer to that, but we did get that question. So presuming that you've done your homework, you've answered the questions, and that there's not a real controversial project, then you get approval. State Bond Commission approval is good in perpetuity. As long as you meet the parameters. Bond Commission approves on parameters. Again, maximum principal amount, maximum interest rate, maximum term. And as long as you're within those parameters, you can actually issue bonds until you've used up all of the authorization that's granted. All of this goes back to our opinion as bond counsel. The very first opinion that we render as bond counsel is that the bonds or other obligations that are subject to our opinion are legal, valid, and binding obligations of that public entity. And that means that they've been duly authorized and issued pursuant to state law, and that they have all regulatory and other approvals required, such as State Bond Commission. So this is why we're very much sticklers on the process and the approval, because we need to be able, for your benefit, to render our opinions. Again, working chronologically, once we get through that, we have sales of bonds. There's a difference between a private sale and what is either referred to as an underwritten sale or a market transaction or what have you. Private sale is just a bank loan, for lack of a better term. It'll be with a small number of lenders. Usually it's just one, sometimes it's more than one. It doesn't have all of the standard disclosure documentation that a market transaction does, but it also usually means that you're working a lot closer with the particular lender in the process to ensure that whatever they want to see in the documents is actually reflected in the documents. That can mean sometimes it's a lot quicker, can also mean sometimes it takes a lot longer. Just depends on your particular deal and who you're working with. I know there are different requirements now under GASB with respect to disclosing private bank loans, and I think we usually have to answer some questions on what are bank loans and what are not. If you're involved in the process on the front end, you have a good understanding of what is a bank loan and what is not. But we're always happy to answer those questions with you as well. The other way of selling bonds is through an underwriter or a market transaction. These are the publicly traded bonds. So if you decided you wanted to go buy a share of bonds in the city of New Orleans or the state of Louisiana, then you could go actually buy a maturity of bonds. Usually they're sold in $5,000 increments, and hopefully you can buy millions upon millions of them. But they are sold either through a competitive process in which there's a notice of sale published, and that notice of sale sets a particular date and time at which all bids for the purchase of the bonds are going to be received, and whoever offers the best interest rate at the time actually gets to buy all of the bonds. The other process is a negotiated sale, where on the front end you hire an investment banking firm or an underwriter, and then you work with them to determine what's the proper day to sell and what's the proper amount, and you're working with them on terms. It used to be that the IRS said that a competitive sale was actually resulted in the best yield for an issuer. That is not necessarily the case anymore. There are fees baked into a competitive sale that you don't see, that you do see in a negotiated sale, which means that you should be able to negotiate those more, thus the name negotiated sale. I don't know that there's any empirical evidence one way or another right now, and I'm not a financial advisor, so I'm not going to advise you which way to go. But I will just note that what was the conventional wisdom about public versus private sales is constantly evolving, and is for both ways. So the ratings process here, usually we provide all information regarding the sale to a rating agency prior to the sale. They take a look at it, they assign a rating. It's usually from A to D. D is default. You don't want to be in D. I'm only bringing this up because for most ratings, if they're S&P, then investment grade is BBB- or above. So anything in the A category is investment grade. For Moody's, that is it's Baa3 and above. So for most of our public bodies in Louisiana, we are in the investment grade category, and that's a good place to be, because that means there's a lot more desire for your bonds. If you fall out of that investment grade category, that's when you fall into high yield, which is AKA junk bonds. But we don't have that very often here. We don't have that very often here because we have really strong statutory procedures to protect bondholders. Bond insurance is another thing that you'll see throughout the process. Bond insurance is where a third party, very large insurance company essentially guarantees the payment of debt service to the extent the pledged revenues don't materialize. However, you can't just enter into a bond insurance agreement just because you want to do it. Instead, under our state law, the bond insurance is only used if there's a certification by one of the finance professionals that the present value of the savings in debt service over the life of the bonds as a result of the bond insurance policy is going to exceed the value of the premium that's paid. So if AGM or BAM, which is the two most common bond insurers, says we'll insure your bonds for $100,000. You'll pay them $100,000 up front, but the benefit is that over the life of the bonds, you should pay less than, you should pay $100,000 less than you otherwise would have. Present valued as well, present valued at the bond yield. And that certification is made by either the underwriter or the financial advisor in every transaction where there's bond insurance. So we've got approval. We've sold bonds. We have closed. We now have ongoing bond covenants. Bond covenants are contractual obligations. Your issuing document, whether it be a resolution, an ordinance, an indenture, a loan agreement, a lease agreement, what have you, becomes a contract with the holders of those bonds throughout the life of those bonds. And therefore you as a public entity are agreeing that you're going to do certain things as long as those bonds are outstanding. So what are those? First of all, let's just say it's a tax-supported bond. You're agreeing that you're going to continue to levy the tax throughout the time, and you're not going to decrease it beyond the level that's necessary for the payment of debt service. You're also not going to extend your debt beyond the time at which that tax expires, because then there would be no funds available for the payment of debt. If it's a utility revenue bond or something along those lines, you would have a rate covenant. Often rate covenants are something that are agreed to with the bondholders. If it's a net rate covenant, it's after the payment of your operating expenses. If it's a gross rate covenant, it's before the payment of your operating expenses. Most of them are net rate covenants and says that the net revenues, therefore the revenues of the system after the payment of debt service, have to exceed X. And that X is usually 1.2, 1.3 times, depending on what type of facility you're operating. If you are below 1.2 or 1.3 times, or whatever is incorporated into the document, then you actually have there are requirements that are placed on you, and they could be as simple as raising rates to undertaking other things such as disposing of parts of the system and using that funding to redeem bonds. Rate covenants are something that utility operators are constantly focusing on and ensuring that they comply with. But just know that when you get into a utility revenue bond financing, there's a chance you're going to have to raise rates in order to continue to pay debt service. We don't do rate covenants in tax-supported bonds. Why not? Because we can't really raise taxes. We can't raise taxes without approval from the voters to raise those taxes. Additional bonds test. I explained refundings earlier in the context of mortgages, but this is where municipal finance deviates from mortgages. Because if you have a home loan and then you have a mortgage loan and then you have a home equity line that comes under it, then when they get filed in the land records, whichever one is first gets priority of repayment over whichever one is second, and then third, and then fourth, and so on. When we do municipal finance, a lot of times we provide for the issuance of bonds on a parity with the outstanding bonds, so long as certain covenant requirements are met in the future, and usually those have to do with debt service coverage requirements. So if you have a sales tax bond and you want to issue additional sales tax bonds, you want those to be on a parity with the existing bonds because you get more favorable repayment terms. With your more favorable repayment terms, you get a lower interest rate. That means you save money. Everybody wants to pay less on their debt service. So we try everything we can to ensure that the new issuance of bonds is going to be on a parity with the outstanding bonds, and that means compliance with the additional bonds test. Insuring the system or the properties, that's insure IN, not EN. That means carrying the requisite amounts of insurance. Investment of funds is both in accordance with state law and if there are any additional restrictions contained within the documents. And then we'll have events of default. So those could be usually what we like to say, if we're allowed, is that upon a default, then bondholders get any remedy that would be granted by Louisiana law. And that would mean a mandamus action to enforce the payment to the extent that funds are available. Acceleration means you get to declare all debt outstanding, due, and payable at that moment. We don't like acceleration because if you can't pay for it in 1 year, chances are you're not going to be able to pay for all of it in the same year. And then cross defaults, meaning that if you have a default on one particular type of bond, it defaults other bonds, and we don't like those either because each one should stand on their own. That is what we're seeing now with the new GASB requirements on private debt and bonds and bank loans. Just real quick, funds and accounts. This is what we mentioned earlier. We refer to this as the waterfall. So revenues come in from either the tax or the utility, and they all go into one particular fund that's established in the bond documentation. That fund may be called a revenue fund, maybe called a proceeds fund. It's got a lot of different names. And then from there is a list of priority payments out of that fund. So first is usually to pay, if it's a sales tax, it's going to the sinking fund. If it's utility revenue, if it's a net pledge, it may go to pay operating expenses first. Then we get to the sinking fund. Well, if it's something that you're collecting revenues on an ongoing basis, monthly basis, you probably have a monthly sinking fund deposit requirement that's equal to 1/6 of your next interest payment plus 1/12 of your next principal payment to ensure that you're going to have enough funds available to make those debt service payments as they come due. If it's a general obligation bond, it goes directly into that separate sinking fund we talked about earlier and can only be used for the payment of debt service. Your reserve funds come next. The reserve funds are typically, there's a three-pronged test that's included in federal tax law, and it is your reserve fund would be funded to the lesser of your maximum annual debt service, 125% of aggregate annual debt service, or 10% of the proceeds of the bonds, aggregate proceeds of the bonds, and it's a lesser of the three prongs there. So to maintain the tax exemption and exclusion from arbitrage of a debt service reserve fund, you have to ensure that you're funded at the lesser of that test. There may be other funds, contingencies funds, renewal and replacement funds, rate stabilization funds. These are all just contained within the same waterfall. And then finally, not a waterfall fund, but a use of proceeds fund is your project and construction fund, where you deposit the proceeds of the bonds and use for the purpose for which the bonds are outstanding and have been issued. With moving along very quickly, because I'm almost out of time, tax covenants are also contained within the offering documents. If you issue on a tax-exempt basis, which most of you do, then your tax covenants are very important because you have to maintain compliance with those for the entire time that the bonds are outstanding. At any time should you fail and the IRS audits and determines that you have failed, they can retroactively revoke the tax exempt status of the bonds back to the date of issuance. The main one I want to highlight here is two of them is use of the bond finance proceeds. To the extent that you change the use, that's referred to very creatively as change in use. But to the extent that you change the use of those that bond finance property, you should contact your bond counsel immediately to ensure that one, it's allowed under the authorizing documentation, and secondly, that it doesn't run afoul of federal tax law. If it does violate federal tax law, for example, if you have a building that you finance and you take it and sell it to a private entity, well, suddenly that becomes private use. Private use is not allowed under the federal tax code, and if you have private use, we have to do certain things with the bonds to ensure that we don't run afoul of that tax exempt status and jeopardize that tax exempt status. I tell people all the time, we can solve most problems as long as we know about the problems in the first place. We can't solve the ones that we don't know about. So contact your bond counsel on that. And then secondly, arbitrage rebate. This is new. For those of you that have been around for a while, you've probably heard of arbitrage rebate but never really seen it. Well, that's because in our rising interest rate environment, we've moved to a place where you're earning 2 or 3% on your deposited funds. And you may have issued bonds in 2020 at 1.5% if it was a short-term obligation, maybe 2%. So we're now at a point where there is there's jeopardy of arbitrage earnings. There are a number of entities out there that do arbitrage rebate analyses. I would really encourage you to talk to those and get in front of them so that you ensure that you do not earn more on your bond-related funds than you are paying on the bonds associated with those bond-related funds. There's a solution to that if it's happening, but we want to make sure that you take advantage of the solution. And then finally, this is my last 60 seconds, continuing disclosure. If it's a bank loan, your required disclosure is going to be included in the authorizing documentation. And then if it's a public debt, it's included in a continuing disclosure certificate. You have a deadline each year at which you have to file your annual financial report. And also any sort of financial operating data that was included in your official statement. There's also a requirement, there's 16 listed events. These will be included within your continuing disclosure certificate. For our clients, we also include a separate post-issuance compliance for you to review that contains them in there. And you should be familiar with them. Things like defeasances or redemptions, payment-related defaults, non-payment-related defaults, incurrence of additional financial obligations, in other words, private placements, all require disclosure and posting on EMA, and that becomes part of your annual audit requirements as well, that your auditor has to review those and ensure, at least review a selection of them and ensure that you have complied with your ongoing continuing disclosure requirements. I see a 0 right there. I don't know if that's my score or if that is if that's the time, but thank you again, Jason Akers, and I really do appreciate you letting us speak with you today. Okay.
Thank you so much. Come a little closer so they can pick me up there.
Here you go.
That's all right. So thank you. That ends day 1. We hope you will come back with us for day 2. For all of those of you online, here's the magic word. Remember to log out of the link tonight and log back into the link tomorrow. If you leave the link on, it won't work tomorrow. So log out, log back in tomorrow. Hope to see y'all. We start at about 8:15. Thank you so much.
Thank you.